Do you want to talk over here real quick?
Yeah.
Okay. So, I'm Steve. I'm with the traffic unit. So, just I know this is probably uncomfortable, but we're just gonna, treat this like as if it was anything else, and we want to figure out what was going on. Just just in order to rule anything out.
Yeah.
Like obviously, it just is important to rule everything out as it is to confirm everything. So, I'm just getting here, so I know you already answered some questions from the other guys, but generally, what happened?
She told investigators she had been out to pick up a pizza. That was the story. A Saturday evening, a left turn at an intersection on State Route 240 in Richland, Washington. A personal vehicle heading home. A pizza, a routine end to a day off. The motorcycle was almost completely under the front of her vehicle when the first officers arrived. Jhoser Vega-Sanchez was 20 years old. He had been riding his motorcycle southbound when the SUV turned left directly into his path. The front right corner of the vehicle struck him at the intersection of State Route 240 and Village Parkway at approximately 7:39 in the evening on March 1, 2025. Washington State Patrol troopers were the first on scene. They performed life-saving measures at the roadside. Vega-Sanchez was transported to Cadillac Regional Medical Center in the Tri-Cities area. He was pronounced dead at the hospital. The troopers who arrived first did something else before transferring investigative responsibility. They identified the driver, and what they found changed the shape of everything that followed. The driver was one of their own. Sarah Clasen, 36 years old, a 13-year veteran of the Washington State Patrol. She was also the Tri-Cities area spokesperson for the agency, the person whose job it was to communicate with the public, stand before cameras, and represent the Washington State Patrol to the communities it served. She was, in the most literal sense, the face the agency chose to present to the public in the region where Jhoser Vega-Sanchez had just died. Within minutes of identifying Clasen as the driver, the troopers who had arrived first transferred the investigation to the Richland Police Department. The reason was straightforward. The State Patrol normally handles collisions on state highways and interstates. But when the driver is a member of the agency, that agency cannot investigate itself. That principle, that a law enforcement institution cannot objectively investigate its own members, is foundational to any credible justice system. What the body camera footage from that night raised was the question of whether that principle was applied immediately, consistently, and without exception from the very first minutes after Clasen was identified. What happened in the roughly 30 minutes between Clasen's identification and the official transfer of the investigation to Richland Police is one of the questions that has followed this case since the body camera footage from that night was obtained and reviewed by journalists. For about 30 minutes, it was not entirely clear who was in charge. The Tri-City Herald, which obtained hours of body camera footage through Washington's Public Records Act, reported on what the footage showed, what the first troopers said and did when they discovered Clasen was the driver and Vega-Sanchez was not likely to survive. The question that footage raised, and that public reporting returned to repeatedly in the months that followed, was whether Clasen received any form of special treatment in those first critical minutes because she was a law enforcement officer. Whether the response to the driver was different from what it would have been if the driver had been anyone else on that road that Saturday evening. When Richland Police took official control of the scene at approximately 8:15 in the evening, their investigation found several things. Officers observed Clasen slurring her speech. They noted she had glassy eyes. They identified what they described as several inconsistencies in her account of the collision. She told them she had been heading home from picking up a pizza when she began to turn and struck the motorcycle. According to the affidavit filed by Officer Steve Hyde, the motorcycle was almost completely under the front of her vehicle as it rested on the side of the roadway. A Richland police officer arrived nearly 2 hours after the crash and arrested Clasen on suspicion of being under the influence. At the scene, Clasen declined to perform standardized field sobriety tests. She refused to take a preliminary breath test. A court warrant was obtained for a blood draw. The draw was conducted approximately 6 hours after the crash. The results came back in April 2025 from the Washington State Patrol's own toxicology lab. Her blood alcohol concentration was 0.17, more than twice the legal limit of 0.08 in Washington State. 6 hours after the crash, more than twice the limit 6 hours later. Clasen was booked into Benton County Jail the morning after the crash. She was released on her own recognizance at her first court appearance. She was placed on paid administrative leave. She kept her badge. She kept her salary. For more than a year, while the family of Jhoser Vega-Sanchez waited for the case to move through the courts, Sarah Clasen was a Washington State Patrol trooper on paid administrative leave. That detail, paid administrative leave, became one of the most discussed aspects of the case in public conversation. Paid administrative leave is standard procedure in Washington State when a law enforcement officer faces criminal charges. It is not a disciplinary measure. It is a legal status that preserves the officer's employment and compensation while the case moves through the courts. The argument for it is procedural. A person is innocent until proven guilty, and employment should not be terminated before a conviction. The argument against it, in a case like this, is the one that Vega-Sanchez's family and supporters raised publicly. A 20-year-old man was dead. His family was grieving. The legal process was moving at the pace that legal processes move, and the person charged with his death was receiving a government salary throughout all of it. The two arguments exist in the same space, and the law in Washington State has answered them in a specific direction. That answer satisfied some people and infuriated others. This is the case ledger. If this is your first time here, we follow evidence. We don't protect powerful people. We don't move on until the case moves. Subscribe and turn on notifications. You don't want to miss what comes next in this one. Benton County Prosecutor Eric Eisinger made a decision early in the case that was significant. He appointed the Spokane County Prosecutor's Office to handle the prosecution. The reason given was Clasen's position as a local law enforcement officer and the need for independent review in the interests of justice. The local prosecutor, in other words, stepped back from prosecuting a local trooper and handed the case to an office with no direct working relationship with the agency involved. That decision was a recognition, stated openly, that this case carried a conflict of interest that the local system needed to acknowledge and remove itself from. Spokane County Deputy Prosecutor Joseph Edwards took the case. Clasen was charged with vehicular homicide, a felony under Washington law. She pleaded not guilty at her arraignment in Benton County Superior Court in September 2025. The defense requested that Clasen's blood evidence be sent to an independent laboratory for analysis. That was their right under Washington law. It was also a window into the defense strategy. The blood draw taken 6 hours after the crash, showing a BAC of 0.17, is the prosecution's most concrete piece of physical evidence. A number, objective, obtained through a court-authorized procedure. But 6 hours is a significant gap in a DUI case. Blood alcohol levels change over time. The body processes alcohol continuously. A BAC of 0.17 at the time of the draw does not necessarily translate directly to the BAC at the time of the crash. Defense attorneys in DUI cases routinely challenge retrograde extrapolation, the mathematical process of working backward from a post-crash blood draw to estimate what the level was at the moment of impact. They challenge the methodology. They challenge the lab. They challenge the chain of custody. They challenge the personnel who conducted the draw. If the defense could raise enough doubt about the 0.17 result, its accuracy, its reliability, what it actually means about the state of the driver at 7:39 on the evening of March 1st, they could create the reasonable doubt a jury needs to acquit. That is the structure of the case as it heads towards September 2026, a number that the prosecution says proves impairment. A defense that says, look more carefully at how that number was obtained and what it actually proves. The case has moved slowly. The omnibus hearing was rescheduled multiple times. Defense attorneys cited the need to review extensive evidence, reports, video footage, lab results. Each delay pushed the trial date further from the night of March 1st, 2025. Each continuance was another month the Vega-Sanchez family spent waiting for a courtroom date that kept moving. The case that was originally set for trial in December 2025 was rescheduled to February 2026, then pushed again to late September 2026, 18 months between the crash and the scheduled jury trial. In that same 18 months, the family buried Jhoser, attended hearings where nothing was resolved, watched the defendant resign from her job more than a year after the crash, and continued to appear in court and in press conferences asking for the same thing they had been asking for since March 2025. Justice for Jhoser. What that phrase means in a legal context is specific: a conviction, a sentence, an acknowledgement by the court that what happened on that intersection was a crime and that the person responsible for it will be held accountable. What it means to a family is something broader and harder to satisfy. It means that the life of a 20-year-old man who was riding his motorcycle on a Saturday evening was worth the full weight of the law, not a reduced charge, not a plea agreement, not a delay that stretches so long that the urgency of the original event fades from public attention. The full weight of the law, applied the same way it would be applied to anyone else who had a BAC of 0.176 hours after killing someone at an intersection. There was also a development that did not directly affect the criminal case, but that added another layer to the public record. Investigators searched the Richland bar where Clasen had been drinking before the fatal crash. Police reported that the search raised suspicions that some evidence in the case had been destroyed. What that evidence was and what its destruction might have meant for the case has not been fully disclosed in public reporting. But the search itself and the suspicion it generated became part of the broader picture surrounding the case. In November 2025, Clasen failed to appear at a scheduled court hearing. A notice was filed. The hearing was subsequently rescheduled. A veteran law enforcement officer charged with a felony missing a court date. The kind of detail that, in a case involving any other defendant, might carry different consequences. On April 1st, 2026, Sarah Clasen resigned from the Washington State Patrol. 13 years of service. The agency's spokesperson confirmed the resignation in a brief statement and declined to comment further while court proceedings remained ongoing. She had been on paid administrative leave since the morning after the crash. From March 2nd, 2025 to April 1st, 2026, more than a year, she had been receiving a salary from the same agency whose uniform she had been wearing when she was identified as the driver at the scene of a fatal collision. The resignation ended the administrative status. It did not end the criminal case. Jhoser Vega-Sanchez was 20 years old. He was from Richland, Washington, the same city as Sarah Clasen. He had grown up there. He was known to his family and friends as someone full of energy, someone who made people around him feel welcomed. His family spoke to reporters in the days after the crash and in the months that followed. They said he had been riding his motorcycle that evening the way young men do on a Saturday. No particular destination, just the road. He was on a road he had every right to be on, traveling in a direction that was his to travel, at a speed that was within the law, at an intersection where he had the right of way, when an SUV turned into his path. The motorcycle was almost completely under the front of the vehicle. He was transported to a hospital and pronounced dead. He was 20 years old. He had his whole life ahead of him. His family spoke outside the courthouse after Clasen's arraignment in September 2025. They said they wanted justice for Jhoser. They said it directly, quietly, without elaboration. Justice for Jhoser. 4 words that carried everything a family carries when they have been waiting 7 months already and are facing the possibility of waiting much longer. The trial is scheduled for September 2026. 18 months between those 2 Septembers, 18 months of continuances and rescheduled hearings, and a resignation that came quietly, on April 1st. 18 months of a family in Richland, Washington, carrying the weight of a Saturday evening that ended on State Route 240. 18 months during which the person charged with vehicular homicide was first a state trooper on paid leave, and then a private citizen waiting for her trial date while the legal process moved at the pace that legal processes move, which is not the pace of grief, and not the pace of a family that lost a 20-year-old son and has been appearing in courtrooms and speaking to reporters and saying the same 4 words since March of 2025. The blood draw result is 0.17, taken 6 hours after the crash, more than twice the legal limit 6 hours later. The defense will challenge it. The prosecution will defend it. A jury in Benton County, Washington, will be asked to weigh it against everything else and decide what it means. What it meant on the night of March 1st, 2025, at 7:39 in the evening, at the intersection of State Route 240 and Village Parkway, is not in dispute by the physics of what happened. A motorcycle was almost completely under the front of a vehicle. A 20-year-old man was taken to a hospital and did not come home. The trial is scheduled for September 2026. When that jury is seated and the evidence is presented, they will hear about the pizza. They will hear about the 30 minutes of uncertainty at the scene. They will hear about the blood draw 6 hours later and what 0.17 means and what the defense says it does not mean. They will hear about a 13-year veteran of the Washington State Patrol who refused a field sobriety test and a breath test at the scene of a fatal collision. They will hear about a motorcycle that was almost completely under the front of her vehicle. And they will be asked to decide whether what happened at 7:39 on the evening of March 1st, 2025, was a crime, and whether the person responsible for it should be held to the same standard as anyone else who gets behind the wheel after 4 hours of drinking and kills someone at an intersection. The question the jury will answer is whether the law applies equally to the person who was driving. The family of Jhoser Vega-Sanchez has been waiting for that answer since the night they lost him. They are still waiting.